court is satisfied that there is a reasonable possibility that it may be substantially true, S versus Jaffer. In turn, the approach the court must follow is to decide whether defense case, considered with the entire body of evidence, is reasonably possibly true. In S versus Radebe, the court said, and I quote, "The correct approach is that the criminal court must not be blinded by where the various components come from, but rather attempt to arrange the facts, properly evaluated, particularly with regard to the burden of proof in a mosaic in order to determine whether the alleged proof indeed goes beyond reasonable doubt or whether it falls short and thus falls within the area of a reasonable alternative hypothesis," unquote. I next turn to the discussion. On count 1, murder. It seems to me apposite to stress that the state's case on the murder charge primarily rests entirely on the testimony of accused 1. As admitted by the accused, she made false statements in an attempt to explain the deceased's disappearance and to divert attention away from her. In the state's view, this makes her the proverbial, quote, self-confessed liar, unquote. The problem for the state with its reasoning is that if the evidence of accused 1 on this score is rejected as false, then the entire state's case on the murder charge equally plunges into falsehood, as no other evidence was presented from which the alleged criminality of accused number 1's actions could remotely be inferred. In the absence of evidence other than that of accused 1, which, as argued by the state, must be rejected, the court would be required to speculate in vacua on possible circumstances which could or might have caused the deceased's death. To do so is obviously impermissible. Contrary to the Causa case, where the appellant did not give evidence, both accused in the present matter testified in their defense. The approach proposed by the state is to selectively accept as truthful some parts of the defense's evidence favorable to the state's case, including their confessed false extracurrial statements and contradictions, from which the court is then required to draw inferences to prove the accused's criminal responsibility, but at the same time to disregard their evidence as false and rejected. There is no basis in law that would justify a selective acceptance or rejection of the same witness's evidence in the absence of other compelling evidence justifying such cause. This might come in the form of corroboration or contradicting evidence from an independent source. However, in this instance, there is no alihunde evidence that either corroborates or refutes the evidence of accused 1 on the interaction between her and the deceased. To this end, the testimony of accused 1 stands unchallenged. Although the accused person's offering of false information in their extracurrial statements pertaining to crimes they stand charged with would, in itself, be sufficient reason to approach the evidence with a measure of caution, there would be no legal basis for rejecting it entirely. The Latin maxim of falsus in uno, falsus in omnibus, finds no application in our law. This means that the testimonies of the accused persons cannot be made out as being untruthful merely because of false statements made by each in the past. Where no evidence was presented by the state that refutes the evidence of accused 1, then her testimony, despite its shortcomings and contradictions, cannot be rejected as false. The court at the same time must equally consider the corroborative evidence of accused 2 as regards certain aspects of accused 1's evidence, albeit to show some form of consistency in her narrative shortly after the incident of what happened. It then seems settled that the criminal responsibility of the accused persons will primarily turn on their own evidence. The undisputed evidence is that the deceased's death was consequential to a physical altercation between her and accused one. Accused one maintained her position that she did not assault the deceased in any manner other than pushing her away from her during the ongoing struggle. In doing so, she had no intent to kill, or did she foresee that pushing the deceased under these circumstances could likely result in death. It is, however, not in dispute that there is a causal link between the final push causing the deceased to fall over and her ensuing death. The cause of her death, however, to this day remains unknown. In deciding whether the final push is culpable, the following surrounding circumstances are taken into account. The physical altercation was started by the deceased, who first started pushing the accused, and she then reacted by pushing her back. This was followed by further pushing between the two, which does not appear to have been serious or violent. The situation was one of two friends disagreeing and neither wanted to budge, even when it became physical. It would thus appear that this was not an instance where accused one came under attack and acted in self-defense. Neither was it raised in her defense. The state's argument that the complainant during the altercation, when moving from the lounge kitchen area into the bedroom, should have, quote, fled, unquote, the scene to find help, in my view, ignores the existence of a friendly relationship between them and exaggerates the nature of the altercation. Another fact is that both girls consumed liquor during the day, prompting accused one to realize that both of them actually had too much to drink, a factor which probably impacted on the mindset and actions of both. In light of the cause of death not having been determined, it cannot be said that the act of pushing per se was of such serious nature that it caused the deceased's death. There is simply no evidence proving that the force used to push the deceased away and her falling onto the bed was such that the accused must have foreseen her ensuing death. The state's contention that a conviction for murder may still follow where the cause of death was undetermined is based on the fact that the deceased was buried and therefore must have been dead. It was not submitted that the deceased was still alive when buried. Neither is there evidence to that effect. Counsel cited the cases listed in footnote 4 above as authority where the accused was convicted despite the cause of death of the victim remaining undetermined. Counsel for the defense countered by pointing out that the authorities referenced by the state are materially different from the present circumstances, as in each of those cases the court was able to deduce from the proved facts that death of the victim was consequential to an unlawful act by the accused. Although a court in principle may convict an accused for murder in circumstances where the cause of death is undetermined, the elements of the offence must still be proved, to wit, A, causing the death, B, of another person, C, unlawfully, and D, intentionally. In the Urina matter, the accused's defense was a bare denial of any involvement in the killing of his wife, despite conclusive evidence of his fingerprint found on a bag containing the dismembered head of the deceased. In this instance, a post-mortem examination report was before court from which inferences could be drawn. In the end, the circumstantial evidence was so overwhelming that it led the court to the drawing of only one reasonable inference, namely that the accused killed the deceased. In the Peterson case, there was evidence of an assault with a dangerous weapon, and the post-mortem revealing a fractured skull and brain hemorrhage, from which the court deduced that the deceased, when hit in the head, being a vital part of the body, was still alive and that the blow caused the victim's death. In the South African case of S versus M.A., The court, when convicting the accused, drew inferences from a multitude of circumstantial evidence, i.e., the deceased's blood in his house and on his clothing at the time of the victim's disappearance, and scratch marks on the accused which he was unable to satisfactorily explain. The court was satisfied that the circumstantial evidence evinced an assault on the victim which could only have been perpetrated by the accused. Based on the facts of each, the above stated cases are clearly distinguishable from the present matter, in that in each of these cases the circumstantial evidence was such that the court could infer from the established facts that the victim died as a result of an intentional, unlawful act on the part of the accused. In the present instance, there is no clear evidence from which the court could justifiably infer that the killing of the deceased was intentional. The state submits that the intention of accused one could be inferred from her feeling of guilt and the accused person's actions subsequent to the passing of the deceased by keeping it a secret and by getting rid of the body. For the court to draw this inference, it must be satisfied that the cardinal principles as set out in R versus Blom have been met, i.e., firstly, that the inference sought to be drawn is consistent with all the proved facts. Secondly, that the inference drawn must be the only inference to be drawn and excludes every other reasonable inference from the one sought to be drawn. Accused one testified that she was shocked when she realized that the deceased was dead after falling onto the floor and went into a panic, calling on the assistance of her brother. The evidence is that she was not in a clear state of mind and simply accepted culpability. Also that she acted irrational by fearing that she would not be believed when saying that it was an accident and would be arrested if the body were to be discovered in a flat. It appears to me that the circumstances that led to the death of the deceased could be described as a freak accident and not something accused one could likely have foreseen. Her reaction thereto appears to be reasonable in the circumstances and, as admitted, prompted the making of wrong decisions to keep it a secret and to rather dispose of the body. When applying the principles set out in Blom to these facts, I am not convinced that the only inference reasonably to be drawn is that accused one unlawfully and intentionally killed the deceased. Thus, I am not persuaded that the accused person's actions and intent after the passing of the deceased translates into proof that accused one acted with intent to kill. On the same basis, neither does the evidence support a finding that accused one should reasonably have foreseen the possibility of the deceased's ensuing death when pushing her away when bitten on her finger. Her actions could therefore neither be found to have been negligent. As regards the competent verdict to murder, there is no evidence from which it may be inferred that the accused either acted with the intent to cause grievous bodily harm or common assault. In the absence of evidence to the contrary, it seems to me that this is an instance where there is a reasonable possibility that the version of accused one may be substantially true and that the state failed to prove beyond reasonable doubt the charge of murder against accused one, or any of the competent verdicts as provided for in Section 258 of the CPA. With regards to accused two being charged with the same offence of murder, having acted with common purpose with accused one, there is no evidence that either proves his presence or involvement in the incident that led to the death of the deceased. Divergent arguments were advanced in this regard by both sides. When deciding whether accused two was an accessory after the fact to murder, based on his assistance to accused one to dispose of the body, his culpability depends on A, whether a crime was committed by accused one, B, his knowledge about it at the time, and C, notwithstanding assisting her to escape justice. The learned author Snyman at page 272 on the liability of an accessory after the fact states that, quote, There can only be an accessory after the fact if somebody else has committed the crime as perpetrator." End quote. The court having found that accused one was not liable for the death of the deceased, it then follows that the principle of an accessory after the fact finds no application as regards accused two. Consequently, the guilt of both accused on the charge of murder has not been proved beyond reasonable doubt, and they stand to be acquitted. Count 2, robbery. As mentioned, the state changed course and prayed for a conviction on the competent verdict of theft for both accused and relies on the Huibeb matter as authority. The facts in that case are, however, clearly distinguishable from the present in that the court was able to deduce that the accused unlawfully appropriated the victim's cell phone after she was murdered. In the present instance, the unrefuted evidence of accused one is that she discarded the deceased's belongings and had no intention of keeping any of it to herself. With regards to the requirements of intention in respect of the act of appropriation, Snyman at 485 reads, and I quote, "To qualify as theft, excess state of mind must encompass something more than mere knowledge relating to the property and the unlawfulness, and something more than knowledge relating to the act, in the sense that, quote within quote, that X knows that he is handling an article or is in the process of gaining control of it, close quote within quote, or something similar. This additional intention refers to the objective which X aims to achieve by means of his act," end quote. From the evidence of accused one, it is evident that her intention was to get rid of any evidence that could possibly link her with the disappearance of the deceased and not to steal the property. The accused's intention as regards the deceased's personal belongings is thus no different from her intention to defeat or obstruct the course of justice, similar to the charge set out in count 3. In fact, the same properties relied on in count 2 to have been robbed or stolen form the subject matter of the charge of defeating or obstructing the course of justice in count 3. It must then be concluded that the competent verdict of theft to the charge of robbery was not proved. This would equally apply to accused 2. Count 3, defeating or obstructing the course of justice. Despite both the accused having tendered pleas of guilty on this count, this was declined by the state. It would appear that the sole reason for this decision was because the accused did not admit to one of the allegations in the charge, i.e., that the blood of the deceased was, quote, cleaned or removed, unquote, from inside the flat. The alleged presence of blood of the deceased in the bedroom of accused one's flat emanates from an earlier statement by accused 2, who claimed to have seen blood on the bedsheets and head of the deceased. During his testimony, he, however, denied his earlier statement. Similarly, accused 1 also made reference about blood spatter on the wall, which later changed to a blood smear of her own blood. Though the evidence of the accused persons on the issue of blood is unsatisfactory and doubtful, the presence or not of blood in the flat does not mar the basis of the guilty pleas tendered by both the accused. The inclusion of this allegation in count 3 appears to have been done to strengthen the state's assertion that the assault on the deceased was of a violent nature. In the end, there is no evidence proving that the flat was cleaned of the deceased's blood, neither that any damage was done to the floor as a result thereof, or that vinyl flooring was laid as a cover up for the alleged damage. The admissions made by each accused as set out in their respective Section 112(2) statements satisfactorily explain their intention to defeat or obstruct the course of justice, well knowing that their actions were unlawful. Although the state on this count submitted that the accused persons should be convicted of attempting to defeat or obstruct the course of justice, the evidence established that the act was completed in that the cause of death could not be determined. Consequently, both stand to be convicted of defeating or obstructing the cause of justice and not merely attempting to do so. Counts 4 and 5, fraud. As mentioned, accused 1 pleaded guilty to both counts, and the state, having accepted the pleas as set out in the section 112(2) statement, I am satisfied that accused 1 admitted to both offences when pleading guilty. On these charges, she stands to be convicted. Conclusion. Can the both accused please rise? In the result, it is ordered on account 1, murder. Accused 1, not guilty and discharged. Accused 2, not guilty and discharged. Count 2, robbery with aggravating circumstances. Accused 1, not guilty and discharged. Accused 2, not guilty and discharged. Count 3, defeating or obstructing the cause of justice. Accused 1, guilty. Accused 2, guilty. Count 4, fraud. Accused 1, guilty. On the alternative count of theft, accused 1, not guilty and discharged. Count 5, charge of fraud. Accused 1, guilty. Alternative count of theft, accused 1, not guilty and discharged.
Ask the court, please.
Counsel, what is the position? Are you ready? We can take a break now. Are you ready to proceed?
My lord, I would have to take instructions from our client. We probably would not be ready with mitigation today.
Tomorrow?
But I think it depends on the state. Tomorrow,
well,
we
Mr.
could
Mahongo, does the state intend leading evidence in
Available.
No, just listen to my question. Does the state intend leading evidence in aggravation of sentence?
No.
No, thank you. So with that brings us to you, Mr. Titus and Ms. Larson. When will you be ready? How much time do you need? We are pressed for time.
My lord, I can be available tomorrow for mitigation.
Ms. Larson?
If the court is so inclined.
I am also available, my lord, for tomorrow.
Tomorrow is Wednesday. No? Yeah. Mr. Mongo, are you available tomorrow?
Yes, my lord.
Okay, I think then to allow counsel then sufficient time to consult in light of the judgment, which they would need to work through with their clients, that it would be fair to have proceedings adjourned until tomorrow for mitigation of sentence. Okay. Accused number 1 is she detained at
Klein
Windhoek
police station, my lord.
It is then ordered that proceedings adjourn to 17 May 2023 at 10 o'clock for mitigation of sentence. Accused 1 remanded Klein Windhoek Police Station holding cells. Accused 2 remanded in custody Windhoek Correctional Facility trial awaiting section. Understood?
Who's the court leader?
Support leaders.
Priska, it's just one or two corrections that I want to do. No? The court is adjourned. Bring my glass and my water, please.
This is bullshit. For 6 months. For 6 months. They take our daughter. They are not fucking charged for murder. Fucking fucking you take our daughter, man. And put that to a fucking man. Usali lost me. Usali lost me. Wow. Usali lost me. Stop it, man. Stop. Stop. Who's talented, man? You kill our daughter, man. You think we have to understand it? I know, man.
This is good.
They really name it in court that they take the water. They are not doctors in profession. We will appeal against it, man. We will, Mr. Lieberberg. That's nonsense, man. Let's stop this nonsense. That's a professional killer. Those are professional killers. Then they have to come out of prison. Yeah? And you want us to understand that.
From now on, you can start.
Then let me come out of their mouth.
He believes in justice.
Child, man. And even if we're lawyers, no, like this,